Hello everyone, this is Barrister Garn from Siam Center Law Group. Today, let's talk about a question that many families often ask. If a property belongs to a minor, can the parents transfer or sell it? The answer is yes, but only if it's done through the proper legal process. First, we need to understand what the law means by a minor. Under Thai law, a minor refers to a person under the age of 20 who is not yet married. In principle, a minor cannot legally conduct transactions on their own, whether it's selling, transferring, or mortgaging property, because the law considers minors not yet to have full legal capacity or maturity in managing property. That's why any property registered under a minor's name, such as land, a condominium, or even bank funds, must be managed by their parents or legal guardians. However, that doesn't mean parents can do whatever they want with the child's property. The law is very clear under Section 1574 of the Thai Civil and Commercial Code. Parents may manage the property of their child only for the benefit of the minor. So, if the transaction may directly affect the minor's property, for example, selling land, transferring the property to themselves, giving it away as a gift, or using it as mortgage collateral, then by law, they must first obtain permission from the court. Now, let's look at how that process works. Step 1. Contact a lawyer to prepare a petition to the court. The petition must clearly explain the reasons and show that the transaction truly benefits the minor, not the parents. Next, attach all supporting documents such as the child's birth certificate, house registration, land title deed, marriage or divorce certificate, and both parents' identification cards. Once the petition is filed, the court will schedule a hearing. Both the parents and the minor will be called to give statements at the Observation and Protection Center for Children and Youth. Officials there will interview them to find out why the transfer or sale is being made and whether it truly benefits the child. The center then submits a report and recommendation to the court. After that, the court will conduct another hearing to consider the petition. If the court finds that the transfer is transparent and genuinely benefits the minor, it will issue an order granting permission. Then, the parents must wait for the judgment to become final, usually about 30 days, and bring the final judgment certificate to the land office or relevant agency to complete the transaction. In most cases, the entire process takes around 2 to 4 months, as long as there is no objection or dispute. So, to summarize, whenever parents want to sell or transfer property that belongs to a minor, they must file a petition with the court first. This ensures that the court reviews whether the action truly benefits the child, which is the spirit and purpose of the law. The goal of this rule isn't to limit parental rights, but to protect minors from losing their property or being taken advantage of without understanding. That's why every transfer of property owned by a minor must go through the court first to safeguard the minor's rights and ensure fairness to all parties involved. Thanks for watching. Don't forget to subscribe to our channel to get first-hand news.